I want to state from the outset that Labor will be supporting the COVID-19 Disease Emergency Commercial Leases Act of 2020, and I thank the Minister's Office for the briefing yesterday. And following this, I have a number of questions I'll be raising and seeking clarification on a number of points and aspects of the bill. This is an important piece of legislation that is consequential to the National Cabinet Mandatory Code of Conduct, the Code, and the National Code comes into effect from a date following the 3rd of April and is envisaged to continue during the period of time the JobKeeper payments remain operational. The Code applies where the tenant has signed up for the JobKeeper program and that have an annual turnover exceeding $50 million per annum or less. The primary purpose of the Code is to set good faith leasing principles for application to commercial tenancies between landlords and tenants where the tenant is an eligible business under the terms of the JobKeeper program and to aid with cash flow for tenants. It is intended that landlords will agree to tailored, bespoke and appropriately balance the interests of tenants on a case-by-case basis. This is about acting in good faith and supporting landlords and tenants. And I know that many would have done so outside of this legislative framework, and I thank them for that. And as others have said, protections and support for landlords must also be considered in our response to this period of sustained financial hardship. I want to turn now to the state legislation before us. This is an important piece of legislation to support and protect small to medium commercial tenants' rights around our beautiful state. Small business is the backbone of our economy, and our small business owners have suffered tremendously during this unprecedented time. In fact, the last 6 weeks have been an incredibly difficult time for our communities right across the state, and small businesses have made heartbreaking sacrifices to support the health and wellbeing of their communities and local healthcare workers, and I want to put on the record my personal thanks to them for this. This legislation is about setting a legally binding code of conduct and standard for good faith negotiations between commercial landlords and their tenants during a period of unprecedented financial hardship. It's a good thing, but I must admit I'm very interested in the content of the regulations because, as they say, the devil will be in the detail. It would have been good to have these to assess against the legislative framework, and this would have provided comfort to many stakeholders. I know this is not how the process works, but nonetheless it is worth mentioning, and I understand stakeholders quite rightly want to be consulted on the contents of the regulations, and I seek confirmation from the Minister that they will do that.
Speech. Another question that's in the second reading speech. I've committed to that.
Yeah.
In my earlier
Thank you.
Contribution.
I want to also acknowledge the importance of the JobKeeper payment and this mandatory code as good initiatives by the federal and state government, but I also put on the record that there are still some in our community who are not eligible for JobKeeper and obviously not benefiting from it. I'll also acknowledge the grants and support made available by the state government by Business Tasmania during these uncertain times. It is pleasing to see the funding for these were increased, and it will be critical to have the needs of businesses assessed ongoing to determine the need for further intervention, as JobKeeper payments and interventions such as the waiver and deferrals proposed under this legislation are complete. There will be a significant period of uncertainty at this time, and there may need to be extension of such schemes or consideration given to a transitional period. There will be many businesses at the end of this for whom business as usual won't be an option, and we may very well see another wave of financial hardship and economic downturn, and we must prepare for this. I want to congratulate many of our local businesses on their ability and determination to adapt from providing phone and online orders and to home deliveries. Feedback I have received suggests small business is supportive of the code and would like to see it made available as soon as possible to guide for fair negotiations and proceedings between tenants and landlords and to reduce the stress and financial pressures on small businesses. I want to highlight again the importance of wraparound mental health support being provided to our small businesses at this time. It is very important, and I believe that our business enterprise centres and local chambers of commerce may be able to play a very important role in providing this. As we move to an eventual reopening of a business in line with the public health advice which supports this additional support and information for business regarding thresholds for lifting restrictions is required sooner rather than later to provide certainty to enable time to look at different business models which may assist in meeting changing restrictions. I want to move now to consultation on the bill. I received feedback from some involved in the hospitality industry that they had not been consulted on this draft legislation, and I would have thought that they would be one stakeholder group that it would be critical to consult with, particularly given that they may be one of the last industry sectors to re-establish business following the lifting of restrictions. I was also surprised that local chambers that I spoke to on the North West Coast had not been consulted either, and I wanted to understand better those who were consulted with. And so I know that you mentioned that in your second reading speech, but if you could...
Consult with everyone in emergency situations, unfortunately.
it would be great if you could provide a list of those that you did consult with, because that will be really important to identify any gaps and to enable those stakeholders to be heard during the development of the regs. Minister, a previous iteration of the draft bill that was circulated to some stakeholders, I'm informed, is quite different to this final draft circulated to us on Monday. And I will note that I think in your second reading speech you made mention of the fact that parts of that draft bill will now be transferred into the regulations, but I wanted to understand why there have been significant parts removed. And I see that it does appear to be simpler, but it does omit specific details. And I wanted you to confirm that the regulations developed alongside this bill will not include the mandatory requirement for Tasmanian councils to waive or defer commercial rates. And I understand that a commitment has been made by the government that a compulsory commercial rate waiver is not part of this legislation, but I would like you to confirm that. In this new draft...
You're talking about rates?
Yes,
rate
commercial rates.
You have no control in this legislation over rates.
Oh, that's good.
It only deals with leases. Nothing to do with rates.
Good, that's good to hear. Thank you. In this new draft legislation, there is no longer mention of land tax or passing on rates concessions as there was in the previous draft. I did raise this during our briefing and it was indicated that this is still the case, but I just wondered whether the excerpt from the original draft will now be in the regulations, and I note that it is in the National Code, so I just wanted confirmation of that. In looking at the communications section, I wanted to understand better how the requirements will be reinforced and how penalties will be issued or monitored, or the monitoring for breaches as part of the Act. Who will do that and how will that work? Others have mentioned the availability of mediation, and I wanted to understand better how that will be provided across regional Tasmania. The other concern that's been raised with me is around the protection of the reputation of small business owners once their financial position is shared with their landlord through a process of mediation, and around the need for guarantees that this information will not be used against them in future lease negotiations. And I wondered if there'd been consideration other than the penalties on how that might be mitigated. I wanted to better understand the functions of the committee that will be formed, and as others have said, how Parliament will have oversight of that and their role in developing the regs. And I wanted to also understand how people, in identifying gaps that may not be covered through this, would make an approach to the director, or whom they would make an approach to about perhaps having... You've said that there will be flexibility in the regs, so how do people... What is the mechanism for people having influence to that or with that? And that's about how gaps are reported to the Commissioner. And I just wondered at the end of all this how information will be disseminated, and I think my colleague Jen Butler spoke about a flow chart that's available and information that's available in Victoria, and I just wondered, following the development of the regs, what level of information will be provided to landlords and tenants from the government about how they go about working within this framework. You said that you'll consult with stakeholders in the development of the regs, and you said that it'll still go through sub-leg, which is great. Just wondered if you're able to give any more timeframes around the development of the regs and what they'll actually detail. And I now just have a number of questions in relation to the bill. And the first one is on page 11 under 5, protected leases and protected lessees, point 2. Can you explain that clause, which is, despite section 1, a lease is not protected lease if it is a lease or a member of a class of leases that is prescribed for the purposes of this section. And I just wondered if you could explain that a bit further and about those leases that are prescribed, whether they'll be in the regs or...
Can I just confirm all these questions are being asked so that we can avoid going into committee? Or if we're going into committee, then that would be appropriate for committee?
Yeah, I don't think we're intending on going into committee.
Unless there's not effective answers given to our questions and then we move into committee.
What, the 50 million questions you've asked? Well, I will attempt to provide every answer.
Through the chair, please.
Right. Madam Speaker, I'm inquiring because it's a waste of time if they intend going to committee.
Well, our intention is not to, and our intention is just to get some more information about.
And it's usual
The bill.
practice to stand when you're addressing the chair. Thank you. Please proceed.
Thank you. Page 12, under eligible person, just wondered if you could provide some further explanation about point C and that last line there which says about whether or not paragraph A, B or C ceases to apply to the person during the financial hardship period. And what that actually means, my understanding is that it's a bit broader than what's in the National Code. And if you could provide details of why that's there, and that would be good. Thank you. The other questions that I have is, it's been mentioned by others around licences, and I wondered why licences weren't included in the legislation, only leases. Had concerns raised about around the terminations of leases and whether those lessees have engaged in unlawful activity or causing willful damage to a property, whether there are restrictions around that or exemptions around that, I should say, under section 7 around the meaning of prohibited leaseor action. Part 3, application of the Act, point 11. Was there any consideration given to inserting leaseor in subsection B? And on section 12, there's no mention of good faith, and I just wondered why that wasn't included as part of that section. And then part 4, in the interpretation of section 14, that had it raised with me about whether the way that reads, it could be inferred that it was more broadly around economic changes, not in relation to COVID specifically. And my assumption is that because this is a COVID-related bill, that it's absolutely about COVID and the response to the economic downturn and the pressures on business in relation to that. Is that a correct assumption to make, or should there in fact be reference to COVID in that part of the bill?
We obviously deal with recovery as and when required as well.
Yep, okay, thank you. And then the last couple of questions that I have, thank you for bearing with me, is around part 4C, whether the agreement is oral or in writing, or partly oral or partly in writing. It sounds fairly loose. If you could provide some more information regarding that. 12C, do leaseors have to declare that all their commercial leases to their tenants? Something that's been raised with me also. At 18.4, there's a point there that says a leasee may in writing waive the application to the leasee of a provision of this section, and I just would like to understand what that would look like in practice, please. And that completes my contribution, and I thank you very much for enabling me to do so.
Thank you.